This video will be my third presentation of extracts from talks at the 19 Nurses and Manchester Innocence Project event that was held at the University of Manchester. In this third video, we're going to begin by examining a talk by Dr. Peter Hayes, who has been an excellent producer of philosophical material on the conviction of Lucy Letby. Dr. Hayes taught politics and history for over 30 years prior to his interest in the Lucy Letby case. In this extract from his talk in Manchester, Dr. Hayes talks about the pursuit of Lucy Letby, which is often compared to a witch hunt, and also goes into some of the specifics regarding the curious evidence and assertions of Professor Owen Arthurs in court.
So the foundation of the case against Lucy Letby, I think, was one of pure suspicion. And the form it took was one of turning an unknown into a kind of a known inner certainty. So it started out, if you think about the doctors, they think, we do not know why the babies collapsed or died. We only know why they didn't, and therefore we do know. We know that Lucy Letby did it. And I think that was the essential way in which they thought. I think that encapsulates it reasonably well. And to justify the transition then from not knowing how these babies died or collapsed to knowing, the persecutors of Miss Letby created so-called evidence to fit the suspicion, and then refused or only pretended to test the evidence that they'd concocted. This was the evidence then that got Miss Letby convicted, and she then went to the Court of Appeal with her plea to try and be able to appeal. So let's move on then to the Court of Appeal and look at what the judges did. So the Court of Appeal judgment rejecting Miss Letby's plea to be allowed to appeal was thoroughly irrational, I think. And we can ask, in penning this judgment, were Dame Victoria Sharp and Lord Justice Holroyd and Mrs. Justice Lambert DBE, were they animated by the principle of suspicion? I'm not sure. The idea that these judges might have been so biased is a terrible prospect. But the principle of suspicion at least involves an element of sincerity and alternative explanations of the conduct of these judges, such as sort of treating the case as some kind of game or something like that. I think alternative explanations are perhaps even worse. Anyway, whatever the state of their inner consciousness of these judges, the Court of Appeal not only endorsed the irrational arguments of the prosecution, but they added more irrational arguments of their own. So to show this, I'm going to critically examine how the judges responded to the defence submission that with respect to intravenous injection of air to cause air embolism, there was no case to answer. That's one of the things the defence said when they wanted to appeal. And that submission, of course, was correct. This business about intravenous injection of air was founded entirely on suspicion. There wasn't ever any evidence. But the judges said no, there was a strong prosecution case for intravenous air injection. And they argued this by fitting the expert evidence of both Professor Owen Arthurs and Dr. Darry Evans to the suspicions against Miss Letby, and also manipulating the evidence that the defence had put forward, the evidence of Professor Shu Lee, to make this evidence appear to be, quote, irrelevant. I'll turn to Dr. Evans's first and look at what the Court of Appeal said. So the Court of Appeal presented what they said was a hypothetical account of expert witnesses' reasoning that Miss Letby made intravenous air injections based only on suspicion. And you can see it there on the right-hand side of the screen. So the Court of Appeal said if any witness had given evidence to the effect that he or she could not identify any other possible cause of the baby's collapse and therefore assumed on that basis alone that the baby's collapse must have been due to an air embolus, that evidence might well be criticised as mere conjecture. And that isn't, in fact, a hypothetical account. It's exactly how the expert witnesses reasoned, and we can compare it with Dr. Evans when he was interviewed by Dr. Raj Prasad on intravenous air injection shortly after the trial. And Dr. Evans identifies, as you can see, cases where your diagnosis is made by ruling out other factors, and you end up with the diagnosis where this is the only explanation. You've ruled everything out, what's left is the diagnosis. However, we should add that Dr. Evans said that sometimes you had what he called a full house of evidence of air embolism. And that included evidence of coming from the X-rays, and it included evidence with regard to skin discoloration. And the Court of Appeal made a similar claim. And by dropping Dr. Evans's observation that you only sometimes have a full house, it justified its description of mere conjecture as being merely hypothetical. So according to the Court of Appeal, the suspicion that Ms. Letby made intravenous injections are always supported by a full house of evidence, although their preferred metaphor was a constellation of factors, with its kind of the suggestion that there were kind of countless pieces of evidence there. So we want to then look at how this mere conjecture, that the Court of Appeal, using the Court of Appeal's term, then was turned into a constellation of factors. And two of the ways in which this is done was by having the images of gas observed in X-rays of some of the babies being said to form a basis for a diagnosis of air embolus. Again, that's a direct quote from the Court of Appeal. And second, their argument that the skin discoloration seen on the babies was said to be consistent with air embolism. So I'll turn first to the X-rays. This is where the Court of Appeal supported a pseudo-test that was conducted by Professor Arthurs. So Professor Arthurs, a consultant radiologist at Great Ormond Street Hospital and a witness for the prosecution, conducted research in preparation for Ms. Letby's trial. And his findings supported the defence, but he twisted them to support the prosecution. And instead of criticising this twisting of the evidence, the Court of Appeal reinforced it. Let me go on to Professor Arthurs, what I call Professor Arthurs' real test. So Professor Arthurs did I think, actually a very helpful and genuine test. He looked at the pertinent X-rays of at least 7 of the babies where Lucy Letby was alleged to have attacked them by means of intravenous injection of air. So he looked at least 7 of these babies, or the X-ray images of at least 7 of these babies. And in imaging of 3 of the babies, he could see gas in the great vessels, meaning the blood vessels around the heart. What Professor Arthurs then did is he reviewed the X-rays of 500 babies who had died at Great Ormond Street Hospital, and where there was no suspicion of intravenous air injection. And he did this, as the Court of Appeal judges put it, to satisfy himself that seeing gas was unusual. As it would be, for example, if imagine if he'd looked at the 500 cases and he'd only seen in 1 or 2 occasions that there was imaging of gas in the great vessels. So if it was only 1 or 2 times out of 500, then certainly that would be unusual. But in fact, Professor Arthurs' assumption was refuted, because far from being unusual, he saw gas in the great vessels in about a quarter of the cases, in about 125 cases out of 500. So he saw it about a quarter of the time. So if gas can be seen in the great vessels about a quarter of the time, about 125 times out of 500, when intravenous injection is not suspected, then is seeing gas 3 times out of 7, is that unusual? Is that suspicious? Obviously, the answer is no, it isn't. So, as I say, with this review of 500 babies, I think Professor Arthurs had conducted a real test, and one that showed the jurors, who perhaps, contrary to their intuition, that seeing gas in the great vessels is commonplace, and it wasn't a suspicious society at all. And what do the judges say about this? They say nothing. They're completely silent on the implications of this finding. And then they undertake what philosophers of science call a degenerative problems shift. And they try again with 38 of the youngest babies and find that 8 of them show gas. Is that significantly different from 125 out of 500, or indeed 3 out of 7? No, it's not. At this point, Professor Arthurs and the Court of Appeal judges run a pseudo-test. It's a kind of a ruse. They take these 8 of the youngest babies where gas has been found, And they don't ask, is this unusual? We know, but it's not. They ask instead, is it unusual for these 8 cases to have been unexplained? And then Arthur says, well, all of these cases at Great Ormond Street, we explained all of them. We knew why these babies had died. So it was indeed unusual for them to be unexplained. And it was that unusualness that was then used by the prosecution to say, well, what's going on in these 3 cases where Lucy Letby was said to be involved? Now, there is some inconvenient facts, in a sense, who Arthur has done when he's gone down to this test of 8 babies. And the first thing, which I find strange, is that on the face of things, at least even amongst these 8 babies at Great Ormond Street, at least one of these deaths, and perhaps several of them, was unexplained because it was classified as sudden unexpected death in infancy. So that's a classification of death for sure, but it's not an explanation, is it? And so it's a bit odd to say that none of these 8 cases were unexplained. But still, that's what we said. And then another inconvenient fact is that, and we've already heard about the post-mortem reports, and so 2 of these Countess of Chester babies, they had post-mortem reports that identified the cause of death as being a result of natural causes. And again, that's ignored, and they just say, well, it's all unexplained, it's unusual, it's suspicious. It is a basis for diagnosis of air embolus, but it's not a rational basis, is it? So we've got these problems, we've got the fact that there is a sudden unexpected death in infancy, we've got a difficulty in that it is not comparing like with like. So if the doctors at the Countess of Chester Hospital insist on saying they do not know how babies died, and if they reject post-mortem findings that say that these babies died from natural causes, then of course the deaths by their account are going to be unexplained. You can't then draw a comparison with doctors at another hospital who do not hold this kind of suspicious attitude and have accepted post-mortem explanations of the deaths of 8 babies. You're just not comparing you can't draw any kind of comparative conclusion from that. There's also no comparative data on the babies where gas is not observed. So in fact, no figures at all are given for any of the other 492 babies in the original test. I mean, we just don't know about how many of their deaths were explained or unexplained. But however, we can assume, I think, that unexplained deaths are also going to have been unusual amongst these babies, including the approximately 375 babies who didn't have gas observed in the vessels around the heart. And if we assume that they also had deaths that were by and large explained, all that Professor Arthur has shown is this. First, he's shown that baby deaths or collapses at Countess of Chester Hospital in cases where this Letby stands accused are unexplained in the eyes of the doctors there. And he's shown then second that it's unusual for baby deaths at Great Ormond Street Hospital to be unexplained. That's all he's shown. That's it.
There are, of course, many unsatisfactory aspects to the injection of air / air embolism allegations, but I've always found it particularly confusing, shall we say, that Professor Owen Arthurs has produced his study which should essentially exonerate Lucy Letby, that indicates that air can be present in infants with some regularity, which is known to be the case anyway, and that this is somehow used against her. And then not only that, but we never actually get to see this study. It's not really a proper academic study. It's not been peer-reviewed. It certainly hasn't been published. It's not publicly available. Why is academic research being commissioned for a court case? There should be existing research, or if research is going to be commissioned, then it should go through the normal academic process. There should be some proper academic rigour. There shouldn't be some half-assed study appearing in a court case that can't be corroborated by anyone. But even though it can't be corroborated, it still points to the accidental presence of air being not an uncommon event. But somehow this is all overlooked in this kangaroo court case associated with the conviction of Lucy Letby. In the next talk, we're going to hear from Professor Claire McGourlay, who was involved with hosting the event at the University of Manchester. Professor McGourlay is both a National and Principal Fellow of the HEA. Claire is currently the Director of External Relations in the School of Social Sciences, the Leadership in Education Awards Programme Champion in the Faculty of Humanities, and the Director of the Humanities New Academic Programme. At Manchester, she was the Director of Learning and Teaching until the School of Law merged with the School of Social Sciences in 2019. Alongside this, she's expanding pro bono work at the school, and Claire was instrumental in creating the Justice Hub and new modules in legal tech and clinical legal education. In 2020, Miscarriages of Justice team in the Justice Hub joined the USA Innocence Project Network, the 13th project allowed to join outside of the USA. Claire publishes in this area and also wrote a leading textbook in criminal evidence. So we're going to hear from Professor McGourlay in this following extract.
In the context of the NHS, which will be a large focus of today's talks, this conversation takes on a particular urgency. The health service is rightly seen as a source of compassion, care, and integrity. Yet, like most areas we see involving wrongful convictions, it is also a human institution, and things go wrong. When pressures are immense, when hierarchy discourages challenge, when blame is used instead of learning, the consequences can be devastating. Too often, we have seen how toxic workplace cultures, poor communication, fear of reputational harm can distort the truth and obscure accountability. The phrase "from flawed beginnings to broken lives" captures, I think, that trajectory all too well. A misunderstanding becomes a rumor becomes an accusation. Unchallenged, this becomes an institutional truth in whichever context you see that. And before long, as many of us in this room have seen, time and time again, and since I was an undergraduate student in 1991, I've been sort of working on these cases. You see persons' lives, reputations, and freedom, and those reputations are damaged forever. And this is not just about the justice system or the NHS or any single profession. It's about how, as a society, we respond to error. Do we rush to blame? Do we seek to understand? Do we silence voices, or do we make space for them? Do we protect systems, which we see across wrongful conviction cases? Do we protect systems, or do we protect people? The wrongful conviction of any individual represents not only a personal tragedy, but a collective failure, and a failure of empathy, of process, and of culture. And while the law ultimately may deliver that verdict, and we've seen a lot of talk about abolishing juries recently after the Leveson report, the conditions that enable injustice are often built long before that first piece of evidence is heard by the courts. Over the course of today, we'll hear from speakers who have lived, researched, and challenged these failures, from legal practitioners, campaigners, and academics, to those within the NHS and other public institutions who have seen firsthand how cultures of fear and defensiveness can take root. We will explore themes of bullying, cover-ups, blame, but also of courage, integrity, and reform. Because the purpose of this conference is not simply to identify what is wrong, but it is to ask, how can we make it right? How can we build environments both in our workplaces and our justice systems that prioritize fairness, truth, and accountability? We must remember that culture is not an abstract thing. It is created and reinforced by the daily choices of ordinary people. Each of us has a role in shaping it by the conversations we allow, the biases we challenge, and the values we uphold, when it would be easier perhaps to look away and to walk away. Almost finished. So as we begin, I invite you to engage not just as professionals, but as people, to listen deeply, to question assumptions, and to think about what that means in your own context. And we'll allow time to have a Q&A at the end where we'll sort of draw all these questions together.
So I think some very interesting philosophical questions asked by Claire there, particularly with regard to the culture that we live in. I think it's becoming very clear that with regard to criminal justice, we don't live in a healthy culture. As I mentioned in the previous video, and I think in discussion with Anna Doherty, in my view, one of the primary issues is transparency. There is a distinct, I would say glaring, lack of transparency at the heart of the criminal justice system, and that is very rarely a good indicator. Finally, in this video, we will hear from a former nurse at the Cancer Chester, Vivienne Blondek, who worked at the hospital for 40 years.
This scapegoat culture is not only unjust, it is dangerous. It drives problems underground rather than bringing them into the light where they can be addressed. It creates environments where healthcare workers are more concerned with protecting themselves than with improving care. It transforms colleagues into potential threats rather than cooperative workers and a mission of healing. And the ideal working relationships are in teams supporting each other, but that gets broken down. Healthcare is inherently complex. It involves multiple systems, processes, and human interactions. So when adverse events occur, they are typically a result of multiple system failures, not individual malice or incompetence. And too often, we see individuals bearing the full weight of organisational and systemic shortcomings. So we need to change this culture. The NHS and healthcare systems worldwide, it's not just here in the UK, there are a number of, we believe, innocent nurses globally that are incarcerated for similar reasons that Lucy and others have been incarcerated. They just happened to be there at the time. So we must undergo a fundamental cultural transformation. We need to move from a culture of fear and blame to one of learning and improvement. And this transformation requires several key elements. Firstly, we must establish genuine no-blame culture around clinical incident reporting. Healthcare professionals must feel safe to report errors, near misses, and systemic problems without fear of personal retribution. My time representing members, I found clinical incident reporting was not supported by many managers because they felt that that was a reflection on them. And it sometimes was difficult to get the information I needed to support the member that I was representing, particularly on staffing levels. So secondly, we must recognise that mistakes are inevitably complex in healthcare environments, and our goal should be to eliminate all human error, but that's an impossible task. So we need to create systems that are resilient to inevitable human fallibility. This means building in safeguards and checks that catch errors before they reach the patient. And thirdly, we must celebrate and protect those who speak up. Whistleblowers and concerned healthcare professionals should not be seen as threats. They should be supported, not silenced or marginalised. One thing here that concerns me a lot is the silence of the trade unions. We need to call them into action. One of the most troubling aspects of our current crisis is this deafening silence from the trade unions. Where are the voices that should be defending healthcare professionals? Where are the organisations that should be fighting for fair treatment and due processes and protection from scapegoating? As was said earlier, the unions have not replied when we contacted them. And I myself am horrified by that. So trade unions have a critical role to play in this. They must advocate for their members' right to work in environments that are free from fear of unfair persecution. They must demand proper investigation procedures that focus on system improvement rather than individual punishment. They must fight for due process in cases where healthcare professionals face allegations. The unions cannot remain neutral when their members are living in fear. They cannot stay silent when healthcare professionals are being criminalised for what may be systematic failures. So it is time now for the trade union leadership, and I'm calling on the trade unions to step forward and address these failures in the NHS and to advocate for the kind of healthcare culture that protects both staff and patients. So the broader pattern now, other cases of injustice. Lucy Letby, while prominent, is not an isolated incident. There are other healthcare professionals currently in prison maintaining their innocence, fighting for years to have their cases heard in appeal courts. These individuals represent a pattern that should concern all of us, a pattern of healthcare professionals being criminalised for complex medical situations that may have alternative explanations. Each of these cases represents not just an individual tragedy, but the symptom of a system that's lost its way. When we criminalise healthcare professionals without fully understanding the complex medical, systemic and environmental factors that may have contributed to these adverse outcomes, we are now risking getting a generation of healthcare workers who are frightened to take on challenging cases. They're too scared to make difficult decisions and too worried about their own survival to focus on patient care. So, as I've said, that this goes across all of the healthcare professionals, not just nurses, but it is mainly nurses that have been falsely accused or used as scapegoats. But every single person working in healthcare is at risk. So the question of expertise in investigations and prosecution, the Lucy Letby case has really brought this out to the forefront. And this brings us to the fundamental question that must be addressed, is how qualified are police to investigate thoroughly complex medical cases? How can criminal prosecution and defence teams, judges and juries without medical knowledge properly judge matters that require deep understanding of medical science, healthcare systems and clinical practice? The current system asks police officers to investigate situations that even medical professionals find complex and ambiguous. It asks prosecutors with no medical training to decide whether healthcare professionals should face criminal charges. It asks juries with no medical background to make life-altering decisions about medical practice and patient care. This is not to suggest that healthcare professionals should be above the law. Rather, it is to argue that we need specialised systems and expertise when dealing with medical cases. We need investigation teams that include medical experts. We need prosecutors who understand healthcare. We need judicial process that can properly weigh the complexity of this medical evidence.
So I think for me personally, while there have been a lot of things that I've learned during my time of investigating the Lucy Letby case, since I began that journey over 2 years ago, it's getting close to 2.5 years now, I think the most surprising thing is how bad the culture is seemingly in the NHS. Now, I don't think I began with an idealised view, and I always expect there to be problems in hierarchical organisations and big systemic institutions, but I am still a little bit surprised about how corrosive it appears to be, considering the number of people I've spoken to that have encountered problems, and then we've heard what happens to whistleblowers, we've seen what can happen in terms of bullying, and it appears that people can be targeted as well through this blaming culture that seems to be almost endemic. And overall, that's very worrying. Now, I'm sure there are lots of people that are doing their best, and I'm sure there's a lot of good people working in the NHS. I'm sure there are good things that happen, and I'm sure there are examples of good working culture. But it's more than a little worrying, not just the extent of some of the things that we hear, but seemingly how common they are. One of the things I've encountered in the comments section of my videos is just so many people saying, this doesn't surprise me at all, or giving anecdotes about the toxic culture that exists in their area of the NHS. I've had people emailing me saying my friend, wife, son, daughter, etc. is in the NHS, these terrible things are happening in a way I want them to get out, it's their job, they're passionate about it, but I want them to leave, I want them to do something else, and so on. And this happens to me all the time. I wouldn't like to hazard a guess of how many comments like this I've seen and how many emails I've received. So that's what Vivienne is talking about in this video, and I don't know how we would even begin to build a healthier culture, but again, I think the first step is transparency always. But I think it's also about respect. It's quite clear to me that nurses don't get sufficient respect within the system, and that needs to change. Finally, I would just like to mention 19 Nurses again, who have done a brilliant job with their campaigning. If you are able to join the organisation as a healthcare professional, please do so. And their YouTube channel is definitely well worth following and subscribing to. You can see the full-length version of all the videos featured in this presentation on that channel. With that being said, I hope you've enjoyed this presentation, and I'll have another interview for you in my next video.